afternoon.
Okay. Is everybody there? Johan, middag.
Middag, voorzitter. Afternoon, Chair. Chair, I don't know if everybody is present. Maybe if the members can just all introduce themselves, because I'm a bit confused now because we've got members of, or potentially of, two different committees here. So, Nomfundo, you've got the list there as well, the attendance register. You can maybe assist me and tell me how many of our members do we have? And I just forgot now, what is a quorum for this committee? How many members do we have?
A committee of 10 members.
Yeah, so quorum will be 6.
Would be 6, that's correct.
Yeah. Noms, how many members do we have for our committee now?
We have 60 members. We have 2 ANC, 1 EFF, 1
Yeah, but I'm
FX.
yeah.
Oh,
Sorry, Chair. I mean, how many members do we have present now
okay.
Yeah.
Let me check for you.
that you've ticked off there?
So remember, Seleko, Chairperson, can I be excused just for about 4 minutes time and then I'll be back?
8, 9, 10.
Okay.
We have 10 members, Johan.
In the meeting.
Yes.
Oh, okay. Chair, there we go.
Are we all permanent members or just the alternates as well, Nomfundo?
Oh, these are permanent members, Chairperson.
I see the hand of Deirdre Bartman. Member Bartman?
Hi, thank you, Chair. I'm just making sure that the permanent members of Premier are not being counted. For example,
exactly.
myself, I'm visiting here today. Thank you.
You know, I think that's what I'm saying, Member Bartman. There's an ad hoc committee of the Powers Bill that's got 10 members. And we need to have those members here. If there are permanent members that are not here and there's alternate, that needs to be clarified as well. I know Member Bosman is 1, then is 1, 2, and 3, then is 4, then is 5, then is I count 5. Who's the 6th one? Oh, yeah.
It's 7 permanent members, Chairperson.
Okay, cool. Okay, colleagues, if you got that, then I will welcome all the members to our second meeting since the meeting where they had the election of the chairperson of the ad hoc committee. Before we start our meeting, colleagues, I will just ask that we just have a minute of silence and meditation, and also thinking about what is currently taking place in Swellendam while we are having that minute. Can we start now? Thank you very much, colleagues. Colleagues, I would start with the openings and welcome. And my name is Mbulelo Isaac Sileko. I am the chairperson of the ad hoc committee of the Powers Bill. And I would want to welcome each and everyone that is online and those ones that are watching us on YouTube. Before we start our meeting, I will just give each and everyone who is on the platform an opportunity to introduce themselves, as I have done. Thank you.
Good afternoon, Chairperson, and good afternoon, honourable members, officials. Dan Plato, thank you.
Good afternoon, Chairperson. Kayla Murray.
Good afternoon, Chairperson and all present. Derek America, member of the committee.
Good afternoon, Chair. Gillian Bosman, a member of the committee.
Afternoon, Deirdre Bartman, member of the Premier Committee.
Afternoon, Chair. Gerrit Pretorius, member of the Premier Committee.
Afternoon, Chair. The other member may go.
Peter Marie, member of the committee. Thank you.
Christopher Fry, member of the Premier Committee, Chairperson of the Premier Committee.
Thank you very much.
Afternoon, I'm Nomin Kondlo.
All the members, did all the members introduce themselves, colleagues? I believe so. And please let's note that Member Maseko has asked that she be excused for about 4 minutes, and then she'll be joining us. Joanne, is there any apologies from your side?
Chairperson, yeah, sorry for taking so long. Yes, Chairperson, there is. Member Christians sent in an apology. He's apparently on a oversight visit. Thank you.
Okay.
That's the only one I received, sir.
Is that the only one you received? I will also give this opportunity for the officials to introduce themselves so that we know who is on or online as well. I think we've already heard your voice, Joanne Vermeulen, who is the procedural officer for this ad hoc committee. And I will ask other colleagues from the staff to introduce themselves as well, please.
Good afternoon, Chair. Themba Keswa, PEO. Thank you.
Thank you very much.
Good afternoon, Chair. Matthijs Odendaal, Communications.
Thank you very much.
Chairperson, my surname is Marston. I'm the legal advisor for Provincial Parliament assigned to this committee in respect of this particular bill. Thank you very much.
Thank you very much. Is that all? Okay, thank you very much, colleagues, for those introductions. Colleagues, today this is our first meeting since I was elected as chairperson. And our work basically was just to make sure that we deal with the soliciting of comments in terms of this particular bill, which is the Provincial Powers Bill. And we all know that this bill has been introduced by the Standing Committee on Premier and Constitutional Matters. So today we are going to give them an opportunity as a committee to brief us on the bill. And then after the presentation, we are going to allow members to ask probing questions on the bill. When we are done with that, and members are satisfied in terms of the answer that they have received from the presenter, then we will have to consider our way forward in terms of this particular bill, which all will mean that we'll have to decide which way are we going to go as another committee in terms of getting comments on this particular bill, because that is our work. And once we're done, then we will have to make some resolutions if there is any. I think that's what we're going to do during this particular meeting. Also, what I will also allow as well is that I will also give the PO an opportunity to engage, as well as the communication, and also for Advocate Masdorp, should there be any questions of clarity in terms of the legality of the questions or of the processes that we are going to engage on as the ad hoc committee. Without wasting any of your time, colleague, I will ask the chairperson, Member Fry, to brief the committee on this particular bill. Thank you very much.
Thank you very much, Chairperson, and thank you for the opportunity. I will now share my screen. If you just give me just a second. Right, just confirming that you can see my screen.
It is visible. Thank you very much.
Thank you very much. Chairperson, and to the members of the committee, the Provincial Powers Bill, in its essence and in its simplest form, seeks to create a framework for addressing the failures of national government, and how do we address those failures, and through which channels the provincial parliament and the provincial government will address these failures. So I've prepared a small presentation on this bill. When we look at the principles and objects of the bill is intended to create a framework for the Western Cape to assert its existing constitutional, legislative, and executive powers. These powers seem to look at the areas where the national government is either unwilling or unable to act in the best interests of the residents of the Western Cape. This bill will then create an overarching framework within which subjects for specific provincial legislation, regulation, and policies, proposed national legislation, and requests for the delegation of national competencies will be considered. It's also important to note that the Western Cape government will act in collaboration with local governments in the province where applicable. So the impact of the bill. The impact of the bill is as follows. It will strengthen the mandate of the legislature as well as the executive in order to deliver services where the national government is failing to do so. It will lead to better service delivery, strengthen public governance at subnational and local level. It will promote subsidiarity, which is bringing government services as close to the people as possible. It will establish the Provincial Powers Committee, and it will lead to the drafting of provincial and national legislation. So in the summary of the bill, when we look at the clause by clause summary of the bill, Clause 1 will be the terms that are used in the Act, which is areas of provincial and local autonomy. And the other term is used as the Provincial Powers Committee in Clause 5. Clause 2 sets out the 5 objects of the Act, which are to identify and remedy the failures of national government, promote the assertion of existing provincial powers, seek actively the assignment or delegation of additional powers, mandate the government to prepare reports and draft bills, and create a mechanism for the Parliament to introduce national legislation in the National Council of Provinces through its delegates. Clause 3 identifies the 5 areas of where the province should assert existing powers or seek additional powers. They are policing, public transport, energy, trade, including international trade and exports, and harbors. In addition, there are also additional areas where the provincial and local autonomy on the proposal of the Premier, Speaker, or the Provincial Powers Committee can assert through legislation. Clause 3, subsection 3. I know that the presentation that I disseminated through Mr. Vermeulen has got a bit of a typo here. Clause 3, subsection 3 creates a substantive obligation for provincial and local autonomy to promote provincial autonomy in all its actions and to seek the assignment or delegation of additional powers from the national government. So this is where the nuts and bolts of the clause, the bill comes into being in clause 4. Once the bill is passed, should the bill be passed, clause 4 obliges the Premier to table a report for each area of provincial and local autonomy, which will do the following: identify respective powers of all 3 spheres of government, address how national government has failed to govern effectively, list the additional powers the province or municipalities require, draft provincial legislation, and if appropriate, include draft national legislation which will delegate additional powers to the Western Cape. Then clause 5 establishes a standing committee made up of 10 members of the provincial parliament called the Provincial Powers Committee. This committee would consider the reports as stated in clause 4, seek comment from all 3 spheres of government, seek public comment, appoint experts to advise on the reports, and consider what recommendations will come from the reports the Western Cape Provincial Parliament should take. Clause 6 would include the adoption of reports, and the Western Cape Provincial Parliament, afforded 3 months after receipt of these recommendations, would A, approve the report, B, subsequently supplement the report, C, direct the Provincial Powers Committee to introduce provincial legislation, D, direct its delegates through the National Council of Parliaments to introduce national legislation, or E, recommend to the National Assembly in terms of Section 104, subsection 5 of the Constitution, that it adopt or amend national legislation. Clause 7 outlines the requirement of any supplementary reports that are needed to consider compliance with resolutions in clause 6. Clause 7 also outlines the Provincial Powers Committee to consider the reports and prepare a recommendation if any further action by the Parliament is needed. And finally, Clause 8 would be the short title of the bill. That, in essence, is the bill as it stands, the impacts, and the clause-by-clause summary of the bill. As I said before in my introductory remarks, that this bill seeks to create an overarching framework for the provincial parliament as well as the provincial government to address the failures of national government and to create better service delivery by bringing services as close to the people as possible. Thank you very much, Chairperson.
Member Fry, thank you very much for that presentation. It was sweet and short. Members, this is an opportunity for you to engage in terms of the presentation, to ask any questions of clarity that you seek. Is there any hands? I recognize Member Nkondlo, and then after that it's going to be Member Murray. Member Nkondlo.
Thank you, Chair of this Oversight Committee. I just want to understand, Chair, maybe the presentation as it's made from what is referred to as preamble and the assertions that it's making. How are these assertions made at and arrived at? Is it a political statement? Is it something that has been tested? And if it has been tested, amongst others, it speaks about failure of national government and. So how has that been tested against the citizens of this province? Because this is a province with a population and a voting population that has got the obligation to give meaning to the judgment call being made by those who have written this particular presentation. 2, how is this particular presentation and what is being presented here? Where does it draw from the Constitution this particular act or this particular action of actually having something peculiar to what is vested as per the Constitution to provinces, which the Constitution, as we know, is a supreme law of the land. So perhaps with the legal minds that are also here, such could be explained to somebody like me to just understand that what would be the constitutional basis of this piece of legislation that we are. I think these are just my first 2 questions. And maybe, Chair, to just smuggle a third one, is to just understand what is the relationship of this particular piece of legislation. Is it meant to then augment what is in the provincial constitution that we have here? If I can get some clarity there as my just initial thoughts on what has been presented. Thank you very much.
Thank you, Member Nkondlo. Member Murray.
Chairperson, yes, there's not much I can find fault with our Windhoek bill. Basically, it's got the same objectives as the Western Cape People's Bill, but in milder form. I just wanted to know, are you asking for under Section 238 of the Constitution for delegation of powers, or should the word have meant devolving powers? If you delegate, the minister can again undelegate such powers and take it back. Just what are we aiming at here? I'd like to know that, because it's stated very weak there. And then I would like to know, what are you actually seeking? You say, and to seek all additional powers necessary in order to respect, protect, promote and fulfill the constitutional right of all its residents. Does it mean that this bill, as it stands here, should not be considered as complete as to which functions they wanted to be devolved or delegated? Because 238 is not a right. 238 is a discretion of the national minister. It's not a right which we're asking for. Thank you.
Thank you, Member Murray. I also see Member Marie.
Thank you, Chair. Chair, I'm not a legal expert, but my understanding is that the Constitution of the Republic of South Africa does make provision for federalism, as it were. And so I wanted to understand, possibly from the legal advisors, whether they felt that the bill was in line with these principles of federalism set out in the Constitution. But I'd also be interested to understand as well to what extent the bill can be used and applied to other sectors such as policing or rail. Thank you.
Thank you very much for that. Member Fry, I think that's the first round of questions. And then if there's officials that would want to assist in terms of the questions, specifically the one that speaks about the legality of this particular bill, I will also allow them an opportunity to answer. Member Fry?
Yeah. Thank you very much. To answer Member Nkondlo, how are these assertions made? Well, first of all, it was brought, this bill was brought to the Premier's Committee and there were no objections in the meeting when it was being considered. And the committee is made up of different parties. I would also refer Member Nkondlo to clause 4 as my first part of my answer to the question. In that the Premier will table a report for each area of provincial local autonomy, identify the respective powers of the three spheres of government, and address how the government has failed to govern effectively. That is where the litmus test of how these assertions are made will begin. But before that, in order to test with the people, for this bill, it will need to go for public participation. And that's the process that the Parliament is currently following with this establishment of this ad hoc committee. So I will ask the committee that they will go out for public participation in order to answer that answer. I will leave the questions for the Constitution to Advocate Marsdorp, but safe to say that this bill augments the provincial constitution, and there is no conflict with the current bill in the national constitution. And as I stated in the explanatory notes, section clause 1 of the explanatory notes, is that this bill falls within the legislative competence of schedules 4 and 5 of the Constitution of the Republic 1996. To answer Member Marie's question, yes, we are looking for devolution of powers and not delegation of powers. Under Section 238, Member Marie, you are quite correct that it's at the discretion of the minister of the relevant executive authority. But might I also say that the proof is in the pudding. And it is when we introduce legislation in either the province, in the provincial parliament, or in the national parliament through our delegates in the National Council of Provinces, that we will request the devolution of powers to the province in those 5 areas that I've previously outlined, as well as any area that we deem necessary to devolve powers according to schedules 4 and 5 of the Constitution. About the Constitution and federalism, I will leave that to the legal advisor, Advocate Marsdorp, to answer. I trust that those answers those questions, Chairperson.
Thank you, Member Fry. I also note Member Moran, but I will just first deal with the first round and then you'll come for a second round. Advocate, I'll give it over to you.
Thank you, Chairperson. With your indulgence, Chairperson, could I maybe request that you engage Member Maran for his question in case I need to respond to that as well. I, for now, would like to reserve a comment on any of the questions asked for now.
Member Maran.
Thanks, Chairperson, and good afternoon to everyone present. When you notified the hand of the Honourable Mari, my hand was already up, Chair, when the first round was still busy. Look, Chair, yeah, the Honourable Fry, when he basically addressed us in terms of this particular bill and what it stands for, he said that the Western Cape government have identified 5 particular issues, which is transport, police, energy, trade in industry, exports, and then also harbours. I just want to check with him, is those 5 the only ones that they have identified where the national government is failing, or is it like the Honourable Conlev said, to make a political statement? Second, Chair, that will it stop at this 5? Will it be tomorrow we want to have our own army and declare war? We want to have our own this and that? Where will it stop? Chair, and lastly, and in a way the Honourable Fry have answered, have this been tested against the 7.1, 7.3 population of the Western Cape, and what their view is in terms of this particular issue, whether it's devolving some of the powers or whether you call it federalism. Chair, thanks.
Thank you very much, Member Maran. Is there a follow-up, Member Nkondlo, or is it a new question?
It's a follow-up, Chair, if it's allowed, because I could, I think I'm not sure whether you're gonna give Member Mastop, since Advocate Mastop before, or how are we proceeding, because he said he wants to reserve. I'm not sure whether he wanted up until Member Maran speaks.
That's
if
why
you
I
can
was
bite
asking.
that, because I wanted to add a follow-up and ask new questions.
No, I think a question that I think Advocate said I must allow Member Maran before he can comment, and
Okay.
I would give that opportunity to Advocate now, and then you can come after that. Thank you very much.
Sorry, Chair, shall I answer the questions from Member Maran now?
Okay, you can continue, and then after that I'll give to Advocate. Thank you.
Thank you very much. To answer Member Maran's question, clause 3, policing public transport, energy, trade and power and harbours, is quite correct that those are the 5. In addition, clause 3 also allows for the inclusion of additional areas of provincial authority on the proposal of the Premier or the Provincial Powers Committee. Excuse me. But what must be also understood and what must be remembered, that Schedules 4 and 5 of the National Constitution clearly outlines the areas of autonomy that provinces have, and I would encourage the members to look at those Schedule 4 and 5 of the National Constitution to see exactly which powers and which functions are devolved to local and provincial government. So it has to be within the frameworks of Schedules 4 and 5. So as per the Constitution, I'm not sure of this completely, but Advocate Marsthorpe can also comment on this. But as constitutionally, we won't be able to devolve the powers of the Army or the National Defence Force to the province, because that is constitutionally not possible. So it must fall within the areas of provincial or local autonomy within the framework of the national constitution. Again, how has this been tested against the population? Well, this will be the public participation phase of the introduction and the bill process in the provincial parliament is the litmus test, one of the litmus tests to see what the 7.2 million people, which we will know probably next month as per the census publication, what the citizens of the Western Cape feel or think about this bill. So I would say that this bill will be tested against the population in the public participation process. I'm willing to take more questions, Chairperson.
Advocate Mazdop, are you going to come in? Or are you still going to sit outside?
I'm very much inside, Chairperson. Of course, there is plenty to say in respect of this bill. I could not obviously anticipate which questions will be asked, so that I am not fully in a position to respond to the extent that members may expect me to respond. Some of the issues raised may require further interrogation on my side, especially the question raised by Member Murray as far as the fact, or rather the observation that federalism is provided for in the Constitution. That will need some interrogation. But also, I have perused plenty bills in my time at this provincial parliament, and I must observe, since I've been invited to make an input here, that this is the first time that I see a bill where what I would call, I've been searching for another word, but what I would call spurious generalizations are made without foundation, corroboration, or research backing. Nogal under the preamble of a bill. I've not seen that before, so that is a bit foreign, if not peculiar to me. So in other words, I cannot respond to the content of that when I consider a bill's status in respect of its constitutionality.
Could you explain that again? I missed that, Advocate, please. What can't you consider?
Member Murray, please, can you just raise your hand and not just jump in?
But his hand is raised.
When you acknowledge, then you can speak. Advocate Mazdop is on the platform. We should allow him an opportunity to speak when he's done, and then we will recognize members. Let us avoid to chip in colleagues. Thank you very much. Advocate, sorry for that.
Thanks for your protection, Chairperson. I have introduced what I said, and I will repeat it because Member Murray seemed to have a concern. Let me repeat it, hopefully verbatim. I said, in my time at this legislature, I have not come across a bill where the premise, the foundational premise of the bill is founded on politically loaded statements. That, in essence, is what I said earlier. Not just politically loaded, but unsubstantiated, unfounded, and unreferenced, unresearched, as far as the verbatim of the bill is concerned. So, in other words, this is what I said also, Chairperson, through you to Member Murray. I cannot respond to that. since it purports to be the premise of the bill. Because the subsequent sections and clauses, rather, the clauses of the bill emanate, are birthed from those spurious observations that are made. So it was difficult for me to gather, and maybe while I'm thinking about this, Chairperson, I may want to, of course, with your leave, Chairperson, I may want to address this committee further at subsequent meetings, especially after the public has also had their say and their view and their perusal and their appreciation and consumption and digestion of this bill. Then I may want to address this committee again. For now, I would like to caveat that my observations are preliminary.
Okay, I take note of that, Advocate. Colleagues, I'll go to the second round. I see Member Mare, I see Member Matlodi, I see Member Ngondlo, and yeah, those are the three members. I'll
Thank you.
Yeah, continue, colleagues.
Is it my turn, Chairperson?
Yes, sir, it's your turn.
Thank you. Mr. Masterby, you helped us a lot here. You might not know, you helped me a lot. Yes, this bill is founded on politically loaded statements because the bill seeks to say the reason why they want the powers is because of certain failures which is of a political nature, and it's people have different opinions. Is it a failure by the ANC or whatever level why they want these powers? And now they depend on the exercise of a discretion by the very people which they blame for the situation in the Western Cape. They say that the ANC at national level can't govern, they can't do this, but the ANC has the power to say no to that request in this bill in terms of 238. They can say no. I've exercised my discretion and I won't delegate or devolve any of my functions, because that would prove you were right when you said I can't perform the function. It's a bit stupid, I think, but I would say, and I want to ask you, Advocate, 238, there is no discretion there, or is there discretion? Or does 238, clause 238, place the onus on national government to give self-determination and to take international law in consideration and international conventions into consideration? Now, that is not spurious of me, and that cannot be said it's political loaded statements, because it's written in the Constitution, the right of a community sharing common cultures, language, etc., to self-determination. And then it goes further. The Constitution says that when the Bill of Rights is interpreted, it must be interpreted in terms of international law and conventions. So would you say, if 235 is a politically founded and politically loaded premise, can we say the same of 238? Or would you say it's void? 238 is not, if you want to exercise that right, you don't need to premise it on political loaded statements.
Are you done, Member Morea?
I'm finished, thank you.
Thank you very much, sir. Member Seko.
Thank you very much, Chair. Chair, I think we are at the stage where the bill has been sent to this ad hoc committee. The ad hoc committee was created for the bill, specifically for the process of the bill. But I want to find out, maybe because Chris, member is here. Member Fry is here. The opinion of or the legal advice from Advocate Masdorf, the concerns or the political statement or whatever, how we can interpret what he's saying, was that highlighted to the committee where the bill originated? That's the first question. The second question, maybe to Advocate Masdorf. The bill as its form now, is there a clause where it's unconstitutional? And if there is, which clause it is? Because that's why we want to find out if there is anything constitutionally and to what's in the bill where you can highlight that to us for us to have an understanding while member Fry is here to answer us concerning that. We'll appreciate that. Thank you, Chair.
Thank you, Member Maseko, Member Ngondlo, and Member Marie after that. Thank you.
Thank you, Chair. And I would hope that the ad hoc committee, especially the members, would put restraint unto themselves on a committee that is theirs, so that this committee now is not changed to then discuss Advocate Masdorf's response. Because my understanding that him or any other staff member here, theirs would have been to provide us legal opinions. So I'm hoping
Chair,
we can
point
then
of order.
navigate.
Chair, point of order.
Member Maseko.
Chair, I think for on what member Ngondlo is saying, I think all the members, we do understand that we don't have to get a lecture from her. She can ask her questions.
Is that a point of order? Because if you want to engage with me, we can always do that. Go to what is the point of order on what I'm saying and don't attack me as a person. Because this is the thing of just doing emotional response. Because I am on the floor, I respected you, you say point of order, I'm waiting on the order.
Colleagues, okay, thank you very much for that. Colleagues, we started very well, and I think we should continue with that tone and allow members to raise their views, whether we agree with them or not. Thank you very much. Member Ngondlo, continue.
No, thank you, Chair. Chair, I wanted to actually go back to the response of Member Fry, because Member Fry, on my question about the test of what is being referred, because the preamble, the first slide that he presented makes particular judgment call, makes particular conclusions, which I think is important to understand how were these derived to a point where now they cause actually for this particular bill to be in front of us. And therefore, Chair, my worry with the response actually reaffirms what I had made as a comment, that I believe these are more political statements, because first and foremost, if you say to me, you refer to the Premier making a statement, you refer to yourselves a multi-party committee, that again is a political statement, because one would have expected ordinarily, before I even go there, ordinarily for all the legislations as people who are supposed to be lawmakers, there is something that would trigger a bill or a process for us to engage in a law-making process. It could be the fact that there is a gap in a piece of legislation, and such, obviously, there would be a need for the base document that explains to us or those involved how do we arrive, which is where the research part, which would then be able to say, this is how this gap was tested. So I'm worried if it comes back to be amongst ourselves as political beings as we are, including the Premier, that the basis from which we undertake something very fundamental as a provincial bill that has got an indelible impact on the legislative and governance of not only the Western Cape, but the country at large. We refer that the basis from which we say this thing is because in a multi-party committee, this is what we said, in this is what we said. That is why one would have asked that with the population, and he is referring me to a futuristic process. So it's like you wanting to use this particular piece of legislation to test something. So you have not arrived from the onset that indeed there is a basis for this, and this is my argument on this matter. Why I called it. It's more political statements that are being made. Secondly, Chair, is that once again, from where I'm sitting, I don't think it is correct, and I'm sure those would come back for legal opinion or legal explanation, perhaps will mediate from a legislative point of view. It is not correct for Member Kayla Mare to say here, South African Constitution recognized federalism. That is not correct. Perhaps it's a matter of her own interpretation, because the South African Constitution, yes, allocates certain powers to provinces, but nevertheless, those constitutionally and functionally are devolved under a unitary state, being the South African government or South African Republic, through a constitution that is the supreme law. So that is why we ask the question of testing even this, because it now starts to encroach in such, because even the existence of provinces are derived from that particular constitution. And in that particular constitution, it has not made the provisions, it has made provisions of devolution of these powers that are concurrent, as it is stated in the current constitution. So it has not then in extension given any other province, not only a Western Cape, any other province. So by implication, this has got serious implications for also other provinces. So to just discuss it as if it's something of the Western Cape only, for me, I think I'm still grappling to understand the constitutionality thereof, even in the process at which it is happening. So just on those, Chair, perhaps it would have helped to first take this to the legal support that we have here, so that in the next iteration of the committee, we then, based on what a Member Fry has presented, we get that presentation and we allow legal scrutiny by both by the colleagues that are in our legal department or legal unit of WCPP to come back to us, having looked at what is presented by Member Fry, and then out of it have a discussion, so that, because once again, we are political beings, and this is where also the problem lies in this thing, because we can't place ourselves into a process where we become referees and players at the same time, because indeed our subjectivity may cloud our objectivity as in the responsibility of being lawmakers. So I think it would, I'm just making that suggestion that perhaps let's put on hold on this particular conversation and take this matter back to our own legal unit for them to look at what is being suggested and come back and provide us their legal opinion, and we further deliberate on this matter so that we try and avoid, because we know each other, because with this matter about subsidiarity or not, we have ventilated it in the House as different political parties, and we've made our opinions known. So we should not, therefore, in any way try to hamstring and abuse the law and our responsibility as lawmakers to try and take up a political process and make it a legal process. So this is why I'm saying perhaps if we could mediate on ourselves by asking that this matter goes for our legal to give their opinion, comes back to us, and we have a better mediated discussion from the legal prescript with the political views that are held by the multi-party committee that we are. Thanks.
Thank you, Member Nkondlo. Member Marie? It's you, Member Marie, then it's Member Bosman, and then Maran. Thank you. Member Marie, are you sorted?
Sorry, Chair, can you hear me?
Yeah, you're loud and clear. Thank you. Continue.
Perfect. Thank you, Chair. I think it is important just to firstly say that, you know, it's not our jobs as members of your committee to curtail one another. This is a platform where we should be allowed to express our opinions and ask questions. We shouldn't be reprimanded or told not to ask certain questions. We have that right. But I do take exception to the remark made by Member Murray calling this bill stupid. I don't think that's parliamentary. And I also just want to go back to the feedback that we received from the legal advisor. For me, I feel the questions can be answered. The first being whether the Constitution allows for federalism. It's a question of opinion. Maybe his opinion is not that, or that it allows for devolution, but I would like to know. And also whether this bill would hold up to constitutional muster. Those would be my questions. But I'm also curious to know, noting the legal advisor's feedback, what he would have expected in terms of research behind this sort of bill. Thank you, Chair.
Thank you, Member Marie. Member Bosman, then Member Maran after that.
Sorry, Speaker, may I address you? Chairperson.
Member Marie, just you'll be the last one. I've already identified members to address us. Thank you very much.
Thank you.
Chair, I didn't hear. Am I next or is it Member Maran?
It's you, bro. Sorry,
thank you. So on my side, I see Member Maran's hand is as first. So I don't want to take his chance, but I will go.
No,
Chair,
you don't have to take my chance. You are not the chairperson. The chairperson have identified you. Speak.
The Chair, I need some protection here from the members of the opposition. I think people are a bit hot under the collars today. I'm not sure if it's the weather or it's just the general unrest. Chair, my first question. Yes, Chair.
Continue, Member Maran. You will be the second one. Thank you.
My first question would be, just noting from the comment made by Advocate Master, would it then be prudent of this committee to perhaps ask in one of our other briefings for the National Department of Monitoring and Evaluation, as well as the National Planning Commission and the Provincial Monitoring and Evaluation units within the Department of the Premier, to perhaps present some data to this committee on citizen satisfaction with service delivery in the different areas that have now been listed as allegedly spurious statements, because I think that will give us some factual foundation of how citizens perceive services. And we can also invite Stats SA to share with us their research on how citizens of this province perceives or interacts with services. And I suspect good governance, South Africa would also have that. I think that would be helpful. And then my other question, Chair, and maybe I'm not sure if this is a question for the legal advisor to answer. In my reading of the bill, I think the bill does have the capacity to pass constitutional muster. But if the legal advisor can perhaps tell us how the mechanisms currently provided in the draft bill in section 3.1, where it lists the areas where the Western Cape intends to assert its existing provincial and local powers, how that can be practically translated. Because the way I understand it at the moment, there are two ways of doing it at the moment. It's either through an act of the National Parliament or by a national minister delegating those powers to a province. So my question would then be if the legal advisor can perhaps tell us if there's a legal avenue to practically implement Section 3, and also whether the legal advisor can tell us, as the bill is written at the moment, whether he thinks that it will pass constitutional muster. Thank you, Chairperson.
Thank you, Member Bosman. Member Maran.
Thanks, Chair. Chair, forgive me if I've missed this particular issue, but I haven't seen terms of reference for this committee dealing with this particular matter. And I'm asking the Chair because there's a committee of the Premier that deal with constitutional matters. Now, in this particular meetings, we are now posing questions to the legal advisor to deal with constitutional matters. Whether this particular bill will pass the Constitution, or whether there's certain clauses within this particular bill, Chair. And I'm not sure whether it is our task to deal with it, or whether it is the committee of the Premier in constitutional matters to deal with the issues of constitutionality, Chair. I just need clarity in terms of that. Thanks.
Thank you. Before I give the members or Member Fry, if you want to answer a few questions, and Advocate Masdorp also, I would just want to latch on to the last one and just go to Joanne to go specifically in terms of what is the mandate of this particular ad hoc committee, what is it ought to do, and because when it was established, there was a specific responsibility given to it, and it was 80 seats, and every political party was aware that there is such a committee that will be tasked with such a responsibility. Hence, they have nominated certain individuals. Just as a reminder, before the questions are answered, just to Joanne, just to highlight those issues, please.
Thank you, Chair. Can I go, Chair?
You're more than welcome.
Chairperson, yes, you are correct. The terms of reference, Chairperson, for this committee was 80 seed. I can forward that to members again. But in a nutshell, Chairperson, this is the ad hoc committee that has been tasked by the House to consider and deal with and finalize this bill and then report to the House on this bill. So this bill is not going to be referred back at this stage or to be dealt with by the committee who introduced it, which is the Premier Committee. The bill is not with that committee anymore. That committee introduced the bill, but the bill has now been referred to this ad hoc committee. So all the questions that the committee are posing, even obviously on constitutionality to Advocate Masdorp, I would say is procedurally correct, because this committee is the one who, after having followed all the due processes that we are aware of, public inputs, etc., must report to the House and must either report an amended bill to the House or report the bill as it is to the House, or say to the House, no, we find this bill completely unconstitutional, go back to the drawing board, whatever the report will be. So this is just exactly the same way that bills that usually originate from departments get referred to, let's say, a specific committee, let's say an agriculture committee, where they must deal with and then report to the House on the bill. This is exactly the same task that this committee has. This is the committee who has been tasked with looking into this bill and reporting back to the House. Like I said, and I want to reiterate, either the bill as it is or an amended bill. Thank you, Chairperson.
Thank you very much for that, Joanne. Member Fry, is there anything that you want to say in terms of the comments that has been raised by the members?
Chair, thank you very much, and thank you to the members for their comments. It's appreciated. Chair, I am not sure whether the members of the Premier and Constitutional Matters Committee should be involved in this debate, as we, as Mr. Vermeulen rightly said, that we have introduced the bill, and it's for the committee to decide certain aspects and legal opinions and so on and so forth. What I will say though is that we did not have any dissenting opinion when we deliberated on the bill in our committee. The bill was approved by the committee, and there was no legal advice highlighted there by the committee, to answer Member Maseko's point. To answer Member Nkondlo, thank you very much for your suggestion. I appreciate that. But what must also be remembered is that two things I would say here. The testing of the legislation will be in the public participation phase. But what this bill also outlines is subsequent legislation governing those 5 areas of devolution where we seek additional powers. That legislation will also go out for public participation, and that legislation will in turn also be scrutinized by the public and by the relevant committee. So I would say that yes, we are political beings, but there's subsequent legislation that will arise from this bill, should it be passed in its current form, to be interrogated via public participation and by a public comment and comment from the various departments, both provincial and national. To Member Moran, thank you for your question about the terms of reference. I think Mr. Vermeulen has dealt with that succinctly, but I will safe to say that I stand under correction. But as far as constitutional matters are concerned, the Premier and Constitutional Matters Committee only considers provincial constitution matters. So that's what I would say. That's why this bill should be submitted to National Constitution Muster. That will be not for our committee to deliberate or decide. I trust that answers the questions, Chairperson.
Yeah, thank you very much, Member Fry. There's a few questions, legal, a direct question that was also addressed to Advocate Masdorp from some of the members, and I would give him an opportunity to answer those questions. Thank you very much.
So my question,
Member Murray, you will be recognized. Just hold on. Advocate Masdorp.
Thank you, Chair. I think I misunderstood you. I thought you would give Member Murray an opportunity first, but just the following. I would, like I said earlier, I want to reserve an opportunity to revert to the committee to maybe make comprehensive submissions following questions that were raised now in this committee in real time. And one of the questions raised is the issue of whether the Constitution, the national Constitution, allows for federalism. I am obliged to revert as far as that's concerned. But I did premise my initial statements, Chairperson, on the nature of the introductory parts of the bill. And I said that everything subsequent to that is premised on those statements. And it was difficult for me to get a full and comprehensive understanding of the subsequent clauses. Now, if I should just observe the following, I was at pains to find any grounds on which this devolution is grounded, on which it is based. I still have not found those grounds, so there may be something there for me to interrogate. When I read clause 4C, and maybe if the chair will just indulge me, clause 4C provides that the Premier shall, and I'm just skipping some words to make sense. The Premier shall, for each area of provincial and local autonomy, table a separate report addressing the additional powers that the government require in order to rectify national government's failure. When I read that, I made a note for myself, and my note to myself is that that is a nothing statement, because it doesn't add anything to the body of knowledge, because you don't need a bill to say that the Premier shall table a report to address additional powers that the municipality may require or that a Western Cape government may require. That's a nothing statement. So I'll skip that statement. Clause 4, D and E. The Premier shall, for each of the areas of provincial and local autonomy, table a separate report addressing, if appropriate, I won't give an opinion on the drafting quality, addressing, if appropriate, draft provincial legislation, regulations or policies to assert those powers. E, if appropriate, draft national legislation to delegate or assign those powers from national government. That is a dramatic assertion because it provides that a provincial premier shall table a report. A provincial premier shall address, if appropriate, draft national legislation to delegate or assign powers from national parliament. The note I made for myself, Chairperson, and I have yet to come across this thus far in my career, is how one delegates powers to oneself or assign powers from a national entity to a local entity, in terms of which provision of the national constitution that is based. I have yet to find that ground. Clause 5. Just by the way, in brackets, the heading, the Provincial Powers Committee, should be in bold, like all other titles in bolds. In any case, clause 5.1, sorry, clause 5 sub 1 belongs in the definitions of the bill. Clause 6 sub D Clause 6, the Western Cape Provincial Parliament shall consider the report and recommendation, including one or more of the following. Make a resolution to including one or more of the following. D, directing provincial parliaments delegates at the NCOP to introduce draft national legislation. E, recommending to national that it adopt national legislation. Those are, I made a note for myself, those are superfluous because they are already provided for in the Constitution, in particular, Section 68B. And clause 6 sub E is really a restatement with different words of Section 104, sub 5 of the National Constitution. Clause 7, the Premier shall report to Provincial Parliament on any additional action that should be taken by Parliament with regard to any area of provincial autonomy. When I read that clause, I made a note for myself. There's this little thing called separation of powers. And I needed to just satisfy myself that a provincial premier reports to Parliament. There's nothing wrong with that. That's part of an oversight exercise. But reports that Provincial Parliament should take additional action with regard to provincial autonomy. I'm not sure if the dynamic works in that direction, as opposed to the opposite direction. Clause 7.3. I just note, I think it is a typo. The Provincial Parliament shall adopt any resolution, including those in Section 6.1. There is no 6.1. There's only a clause 6. I also perused, Chairperson, the memorandum on the objects of the bill. Of course, some of the content and assertions in the preamble are repeated in the memo of the objects. I noticed that as I just scroll further down, insofar as clause, I will not comment on clause 2.2, because as I said, it's a repetition of the preamble, and I've made some observations in that regard. Clause 3.3, strengthen public governance at the subnational and local level. I must say, Chairperson, I've searched the Constitution, and the phrase subnational, I have not come across it. I have not come across the phrase or the word subnational. It is not in the parlance of our national lexicon, the word subnational. We talk of provincial, we talk of national, and we talk of local. So I'm not sure whether that is an introduction in bills. This is not a political speech. This is a bill, it's a law. What the reference there is to subnational. Is it a region? Is it anything other than national? But then if that's the case, why is the word local inserted there? Is it some other territory that I am not familiar with? Or is it land mass maybe owned by the Nkonyama Trust? I'm not sure what the subnational is. If it is anything other than national, then I think the word local there is superfluous in that sentence. Similarly, to promote the principles of subsidiarity, I think that's a standalone principle. It is common, but then 3.5 is a deduction of 3.4. So it's a restatement. It is therefore superfluous. I also notice, somewhat with alarm, that clauses 6 and 7 provide that no financial implication of the bill for the state, not for Parliament, not for the provincial government, for the state have been ascertained. But this can change. Clause 7. Sorry, item 7, these aren't clauses, it's a memo. So there are no clauses in memos. Item 7, the institution responsible for the costs of the implementation of the bill cannot be ascertained at this time, but this can change later.
Chair, sorry, can I make a point of order?
Honorable Advocate Amalgop, can you just hold on a minute? Member Murray, what point are you raising on?
Thank you, Chair. Chair, I'm concerned at this time, given the previous suggestions that this should be taken to the legal senior advisor, that it's possibly not the most appropriate time to delve into the contents of the bill. And so I would suggest, Chair, through you, that we consider adjourning this meeting and thereafter reconvening once the legal team and the senior legal officer has had the opportunity to peruse the bill. Thank you.
That's a proposal. Is there a second for a proposal?
Yeah, that was a point of order. So you rise on a point of order. You must rule whether it is a point of order or not.
Chairperson, my hand is up.
Member Bosman.
Chair, I would like to second the motion by Honourable Murray that the committee closes now and perhaps get a written report from the legal services team by a senior legal advisor on A, the constitutionality of the bill, and B, if there's any conflict with existing legislation, and then that the committee also resolves to make a decision on the previous suggestion that I made with regards to getting data presented to the committee. And then we look at our public participation schedule to perhaps get an indication of what the people of the Western Cape also thinks. Thank you, Chair.
Is there a counter proposal?
Chair, my hand was up so long, it's lame from
same.
picking it up.
Same here. We raised hands and you have not
You
recognized them.
ignore our hands.
Okay, before I go to a counter proposal, can I recognize Member Murray and then Member Gondlo? Thank you.
Thank you, Chair. Chair, I made a comment which Member Murray, always interjecting on everything, found problems with, but it was just highlighted by our very able advocate Marsdorp here. A lot of things you pointed out is reason for concern. And I said this, what it stands in this bill. I also haven't seen it. You don't pass a bill by and motivated by criticizing the way this bill criticized government, and therefore this is what we want. And they, in fact, we're not a federation, but we devolve powers to provinces, which is the essence of federalism. So I want to support very strongly the comments and observations of Advocate Marsdorp. We're going to take this bill back. It's a hurriedly written bill that in many cases does not meet constitutional legal requirements of what a bill should be. I should know. I have been involved in politics since Jews, Angus. Never seen a bill like this. They assume powers they never had in the first place. The Premier is given powers he shouldn't have and never had in the first place. But it's here and now. Member Murray every time chips in and digress from what is being discussed and the importance of it. I don't support that this thing be treated as suggested by Member Murray. We as a committee has a task to perform, and we shouldn't run away every time to go and ask advice of the Premier. Otherwise, the DA must put other members in this committee.
I agree.
Member Gondlo.
Thank you, Chair. I would like firstly, remember Advocate Marsdorp was on the floor as requested by you based on questions that the same members were asking. And Member Marie opportunistically calls for an order and support a proposal that was made here. And Member Bosman makes it as if it's a new proposal and now that is being supported. That I think is just out of order. because indeed this is a suggestion. We were waiting on the order. The order never came. Instead, now we are engaged into a discussion on how to move. Because I would think, Chairperson, first and foremost, you should have ruled anyway. There was no order from Member Mare. She could just not deal with the issues that everybody asks, that a advocate must speak on this bill. Whilst there was a proposal that you never tested in the meeting whether it is being supported, of taking this matter and allowing the legal unit to come back to us so that we can have further discussions. So now it's coming back. So I think you need to rule so that we can either continue with Advocate Mastop, on the platform, or you then on your own are saying, let's go back and close the meeting. Because I think that's the guidance that we need at this point, because the proposal was there and was never tested, and now it is coming back as a new a proposal by Member Mare, maybe because she is from the governing party, which is unfair in an oversight committee of Parliament.
Member Fry, I see you on.
Yes, Chair, thank you very much. I was just going to say that these are, my summation is that these are deliberations of the ad hoc committee, and I don't think that the Premier Committee members should be involved in this, as this is an ad hoc committee discussion and debate, not for us, as we've tabled the bill and now the bill is with the ad hoc committee. So I request that we be excused from this meeting.
A point of order, Chairperson. A point of order.
Member Ngonhlo?
A point of order. Chair, all of us, you have given us from a matter of point of order that was raised by Member Mare. You have not ruled whether that was order or not, and you are allowing everybody else and all of us to debate whilst you have not ruled on the matter, so that we go back to the discussion. And we would always be reminded here that the rules that are applying in the House applies also in committees. And in the House, when there is a matter that is being debated, you can't be moving and inviting other people to discuss something else whilst that person was moving on the order. It's either you've overruled or sustained what Member Mare, Kayla Mare was proposing. Because she made an order and was still waiting. What was the order on the speaker that is on the floor, which is Advocate Mastop?
Can I ask members to lower their hand? And I would like to make a ruling in terms of the rule about Member Murray. That was not a point of order, and I would just like to apologize to Mr. Basdorf for cutting me off. And I would like him to continue to conclude his remarks so that we can take the meeting forward. Thank you very much. Advocate Basdorf.
Chair, on a point of order, it's not Miss Marie, she's Marie. And everybody phones me in and say, why are they attacking you? I'm Marie, she is Marie, she's not Marie.
It's Marie. Thank you very much for that. There is no master of pronunciation. Thank you very much. Advocate Masdop.
Thank you, Chairperson. Chairperson, I was busy addressing the committee earlier. And, when I prepare for a meeting, especially in a meeting where my views and advices is sought, then I prepare to the best of my ability as an official of this provincial parliament. And I try to the best of my ability to maintain my professional standards and to contain myself and to express myself in the most parliamentary and ethical manner. I have, during my time, chaired countless meetings. I am familiar with protocols and with meeting etiquette. And one of the things in my early days as an executive SRC member at the university where I studied, the moment someone raises a point of order, you keep quiet and the chair directs. And the chair also interrogates whether that is in fact a point of order which will direct the meeting otherwise. So when I addressed the meeting earlier, I, as is obliged on my side, I stopped talking in order to give preference to what purported to be a point of order. 15 minutes later, we discovered it was not a point of order, and I'm expected, I'm instructed, I'm requested to continue with my legal input as I have prepared. Thank you for the protection, Chairperson. One observation I need to just re-emphasize is what Member Fry mentioned earlier, and that is that there is the anticipation of legislation in future. And one observation he also made in his briefing, and is in fact in verbatim in the objects of the bill, is that this bill seeks to be a framework, an overarching framework to unlock future legislation. So, Chairperson, over and above, and maybe even notwithstanding the issues I raised earlier, and Member Murray correctly picked up on some of those issues, notwithstanding those, the one observation that I think this bill deserves is that it is merely a statement of intent in that it anticipates future legislation. If we look at the bill with those lenses, then a lot in the bill is redundant because it's in the national constitution. A lot even in the bill are restatements of existing provisions in the national constitution. In fact, the word assert or the word assertion in the bill appears about 8 times. In other words, what the bill seeks to do is it just restates what province can already do to assert certain powers. It uses the word about 8 times. The very same bill uses the word seek. It will seek to do X, Y, Z. And in seeking to do X, Y, Z, it uses the word seek about 7 times. This bill is a grand statement of intent and merely whispers that future laws will come by this committee or by this in a provincial parliament, which will actually be the nuts and bolts of this desired devolution of powers. So I have nothing further to add at this stage of my input, except that unless the committee directs otherwise, except if the committee has a specific request for a specific issue to be legally interrogated. But Chair, thanks so much for the protection earlier in the meeting. Thank you.
Chair, are you there?
Are you there, Chair?
Chair, are you there?
I'm just sorry with the members. Members, I think we have heard, and I'm not going to allow any hands now, colleague. Thank you very much for that. I think we've been deliberating on this matter for an hour and a half now, and there's a lot of questions raised of clarity, and there's a lot of issues also that was raised by Advocate Masdorp, and I don't think that if we continue with the meeting that we're going to have we're going to reach any consensus in terms of the way forward. As I think what is important, there's uncertainty in terms of whether this particular bill, which was referred to us by the Standing Committee of the Premier and Constitutional Matters, will be able to master. And there's also questions in terms of the functions, the concurrent functions that has been raised, whether it has been tested or not. And I think, colleagues, for the sake of progress and for us as members of the provincial parliament as legislators, it is important that when we engage in issues of legislation, that we make sure that we put the people of the Western Cape in the forefront, and that whatever we deliver to them is something that is going to better their conditions in terms of legislation, and legislation that is going to assist them to better their conditions. And there were two members that made proposals in terms of how we should actually engage, on a way forward. And that was Member Bosman. And I would propose that Member Bosman makes his proposal again, and then I will get another seconder. And then if there is any additions to his proposal, I will allow that. Then if there's counter proposal, and then I will allow that, so that at the end of the day, we are able to reach consensus in terms of the way forward. Because it is very much important that we, as other committee, stick to our terms of reference of making sure that we report to the House in terms of whether this bill is worth it or not. And that can only be done when there is proper guidance or there is proper questions answered. And I would propose that we really allow Member Bosman to make those solutions so that we can solicit that kind of information that can assist us as the members of the ad hoc committee to deliberate and make sure that we fulfill our role as parliamentarians in making sure that we bring something to the House that is going to be of benefit to the people of the Western Cape. Member Bosman.
Thank you, Chair. Chair, the first thing I think we should resolve on is that we get a written legal opinion on the constitutionality of the bill in its current form, and that we also then invite the Provincial Monitoring and Evaluation Unit in the Office of the Premier, the National Department of Monitoring and Evaluation, Stats SA, or the National Planning Commission to give the committee some guidance on the quality of services delivered by all spheres of government in the Western Cape, so that we can sufficiently address the points made earlier by the advocate around the generality of the preamble of the bill, and that the committee then at another time considers what form of public participation we would like to do, because I'm quite curious to hear from the people of the Western Cape on this piece of legislation. Thank you very much.
Thank you, Member Bosman. Before I ask a seconder for that, is there any member that would want to add to what Member Bosman has proposed?
As Chair, we have heard from Advocate Marsdorp. He's a seasoned legal practitioner. Why do you now seek further legal advice? Later on, we'll end up in a constitutional court in any case. I would suggest we accept his report, get it in writing, and that report suffices. We're wasting time. This bill obviously was a hurried job trying to beat the Freedom Front with its People's Bill. So they hurried this thing through without giving much thought to it. I think we should accept the report of Advocate Marsdorp and not belittle him by saying we need other legal opinion on this matter. What he said makes sense. To anybody in this committee that don't agree with it, doesn't understand constitutional law.
Is that a counter proposal? Member Marais,
that is a counter
Chairperson?
proposal, yes, sir.
Chairperson?
My hand is up
Sorry,
long time, Chair.
If I could maybe just sorry, I just need to insert there. I think Member Marais didn't hear me fully, I never casted aspersions on anyone's capability. All I asked for was a written report on the constitutionality. I think Advocate Maastop has given a verbal report, but I would prefer a written report. It was quite difficult to follow the discussion because there was a lot of assertions. So I take great exception to Member Marais saying that I cast aspersions on anyone's professional integrity, because I did not do that.
Yeah, you did not do that. I would
Never
recognize
use the word expressions.
Member Marais, please. Madala, please, Mdala, I'm asking you.
But Speaker, you allow the DA to say
beg
whatever
for your
they want to say.
indulgence. I beg for your indulgence, please. We are almost there. We are almost there. Thank you very much. Member Ngondlo, are you going to add or are you going to come with a counter proposal?
Thank you, Chairperson. Chairperson, I want to support Member Marais, not Member Mari. Now that one has been educated on how to properly pronounce. Thank you for that. I want to support to say that what Advocate Maastop has presented verbally, forced by this meeting, where there was a proposal to do that earlier on, but maybe it was not coming from the right party. That we ask of him to write, to put what he has said in writing and brings back to the committee. And on the basis of that, we make a determination. Because, Chair, from where I'm sitting, what Member Bosman is suggesting of getting all these other departments is what should have actually informed the basis of what this piece of legislation or bill that is being put forward to us. So you can't start in front and go back, because it's too late now to say, let's go and ask so that we then create the basis for the bill. It can't be. Those who were putting together the bill and said we make the argument that there is a problem should have actually started by getting those departments he's referring to, Stats SA, so that that becomes the reference and the data. As it is always claimed evidence-based. Based on that evidence, this is the reason why this piece of legislation is being put up. So I want to support the notion that says advocate is given an opportunity to go and write, and after he has written, he presented it to us in this committee, and on the basis of this, we make the determination. Because indeed, I mean, here this was just explained to us now, because one would have even wanted, because I don't sit in the Premier and Constitutional Standing Committee, that over and above, where is something that actually helps us around that, which is what one was asking from the onset. So I would like to support the view of Member Marais, considering that once again we may just be, reason may just be summarized here on the basis of numbers, not necessarily what is right. Thank you very much.
So I guess that is a counter proposal, because there's a proposal from Member Bosman, and Member Nkondlo subsequently said that she supports Member Marais. So there's two proposals. But before I see Member America, and I see Member Mari as well.
Thank you, Chair, for recognizing me.
And you don't see me, Chair.
Chairperson, notwithstanding the input of Advocate Maastop,
Chair, on the point of order.
Point of order, you're rising.
Chair, I see that you're ignoring me since the beginning of this meeting. My hand was up first. It was up first. The system will show you that my hand was up first long time ago, but you are only acknowledging the Honorable American and the Honorable Murray. You must tell me if you got something against me.
No, I can't do that, Member Maran. My apologies if I do that. And Member America, can you continue, and then we'll give to Member Maran. I don't have anything against you. Thank you very much. Member America, can you continue?
Okay, thank you, Chairperson.
Chair, on another point of order.
Member Maran.
Chair, whoever is controlling the issue of hands, Chair, is deliberately lowering my hand so that my name now appears. Again, there it happens. Again, my hand was up. The person who is controlling the hands is deliberately lowering my hand as if my hand was not up.
But Member Maran, I've already acknowledged you after Member America. So the
I'm asking, Chair, the person who is controlling the hands is deliberately lowering my hand.
Whoever is dealing with the lowering of hands, can you please make sure that you don't lower Member Maran before you have spoken?
Jay, can I speak?
And who's putting numbers to the hands?
Why is there now 3 at Maran's name? And
Exactly.
1 at Mag's name?
Exactly.
Colleagues.
Chair, no, this is totally wrong.
Can I just beg for your indulgence? Just hold on, Member Maran. I see John. Is there something that you want to say? In terms of the hands?
Yes, just in terms of the hands. Chairperson, from the administration side, I just want to make the point that I don't think anybody's controlling the hands. We don't have that authority. Maybe there's just a technical glitch with the system that members must just maybe indulge with, and I can take it up with ICT afterwards. If hands are disappearing and lowering by themselves, I don't know why that would happen, but I don't believe that anybody is controlling Mr. Maran's hand. It may appear like that, but I've had my hand up for now. I see there's a 2 next to it. I'm not sure how this works, Chairperson, because I'm not that technical, but I don't think anybody's controlling it. I just want to make that point. And I would like to speak again, Chairperson, just, I don't want to interfere, but just on the issue of the motions that were raised, but I'll allow you to direct me when to do that.
Okay, thank you. Thank you very much for that, for clarifying that there is no vendetta against Member Maran.
Why only my name? Why only my name?
Can we just, you will speak as soon as Member America is done. That is, it does not matter what number appears in front of your face. I give you that commitment. You will be the next speaker, whether you are number 4 or number 5, in terms of the hands numbers. Please, can you just be with me, my brother, please, man.
Okay, thank you, Chairperson. Can I speak now, Chair?
You're more than welcome. Continue.
Thank you so much. Chairperson, I do not want to devalue the input of Advocate Master, but I think those are valuable comments, and I'm not of the view that we should seek a report from Advocate Master in terms of the constitutionality of the bill. So we need to get a legal opinion, whether it is from Advocate Master or from Advocate Leroux or from an outside advocate or senior counsel, and not a particular report. However, I do agree with Honourable Nkondlu in the sense that I'm of the view that we don't need presentations from all those other institutions as proposed by Honourable Bosman, because whether the introduction is considered political or spurious or whatever term one wish to use, the evidence is all there for all of us to see how services have disintegrated in the Western Cape, and to detailize, those with the failures in a bill. It is not appropriate, and it's never in a bill to say that I can't take a train to Captain's Clip or Metro Rail has completely collapsed, etc., and list instances where those evidence, each and every failure cannot be contained in a bill. So my support goes along with Honourable Nkondlu and Honourable Bosman in the sense that we solicit a legal opinion, and on the basis of that, we as a committee cannot decide on the constitutionality of the bill. We cannot, as a committee, we can draw up a report perhaps and say that based on the opinions that we have been provided with, we recommend to the House that this bill should be withdrawn, because we don't have that power to withdraw the bill. But in conclusion, Chair, I think that this particular Parliament comes to an end next year. We have a congested parliamentary program and committee program. So notwithstanding the solicitation of a legal opinion, we should now also perhaps tentatively pencil in or speak about the nature of the engagement with the public of the Western Cape in terms of public participation sort of program that we wish to embark upon. Because only when you gather all of those information and then you have a sense of how the people of the Western Cape feels about this powers bill. Thank you, Chair.
Thank you very much, Member America. Member Maran.
Thanks, Chairperson. I'm a bit confused now. Because I can't remember that the Honourable Nkondlo and the Honourable Murray have asked for a legal opinion, because that's exactly what the Honourable America asked now, not for a report, but a legal opinion. I'm not sure whether an external legal opinion, because we got legal experts inside. And if we are saying that, like the Honourable Bosman have said, basically we have rephrased his proposal, saying that all in need from the legal advisor, Mr. Marsdorp, is a written report of what they have said verbally in this. Now, Chair, we have asked for Advocate Marsdorp to give his opinion verbally in this particular meeting. And now that it doesn't suit some of us, we are now saying let the advocate give a written report or advice if it will be different from what he have said in this particular meeting, Chair. I stand with the proposal, Chair, that the Honourable Murray made, of which was seconded by the Honourable Nkondlo, Chair. And when I'm saying I'm support that, mine was not with the understanding that the Honourable Murray have said we must get a legal opinion. I mean, the Honourable Marsdorp is an expert when it comes to legal matters. We should not question his qualifications, Chair. I'm not a lawyer. I'm not going to question his qualifications. I go with the opinion that he gave us, Chair, and I stand and want to support the proposal made by the Honourable Murray. Thanks.
Thank you very much. Member Bosman, and then I see Member Nkondlo. Those are the last hands, colleague, and then I'll give to Joan.
Thank you very much, Chairperson. Chairperson, I want to amend my second suggestion, and I want to say that we can, the facts or evidence that I was referring to can even be ventilated during the public participation process, and I want to support Member America that we establish a time frame for A, getting the legal opinion, and for B, starting the public participation process, being mindful of the fact that we do have very little time. And then just as a matter of interest, Chairperson, the Microsoft Teams system automatically lowers our hands when we speak. So if a member's hand is raised and that member interjects, their hand is lowered. Just for information, Chair.
Member Nkondlo, and then after that is Joan.
Chair, I'm a bit puzzled by the two speakers from Member America to Member Bosman. Because, and I want to first reiterate what I think Member Maran was saying, that we got a legal opinion here. Unless we as this committee are saying we are not accepting, and therefore we must then extend. We want a second opinion from Advocate Leroux or any other from outside. But we must first make a determination about what we had received here, because we kept on asking Advocate Mastop to make an opinion on the matters and the constitutionality which he gave. That is what we requested, that such, because it was in verbal form, can be written and provided back here. So that is my understanding, unless advised differently by your able council chair of this committee. Secondly, Chair, is that perhaps you can also clarify, because I'm missing understanding, public participation on what? If indeed we are sitting now saying, let's get this, so that the first and foremost, we need to make a determination about whether what we are dealing with is actually up for any engagement, constitutionality and others to take it. I'm not sure if we were saying if we arrive at a point that this is unconstitutional. So are we taking such to the public? So I'm a bit confused about that schedule that must come out of the meeting about public participation, unless I'm missing something from what colleagues were raising. Thank you very much.
Thank you very much, colleagues. Those were the last hands, and then I would give to Johan. Johan, you asked to speak last. I'll give it to you so that we can.
Yes, Chairperson, I did, but I still see a member Mari's hand. I'm not sure if you see it. I'm not sure if member Mari wants to speak before me.
Oh, yeah, I see it. Oh, member Mari, can you please?
Thank you, Chair. Chair, I seem to be having the same issues as member Moran. Chair, with your indulgence, I think I would just like to say for the record, through you to Advocate Mastop. Advocate Mastop, I in no way wish to or intended to undermine your expertise. In working with you previously, I have found you to be extremely competent, an excellent lawyer, and so I do apologize if it did come across in that way. That was not my intention at all. I would just like to support the proposal that was initially made by Gillian on a report. And the reason for that is because, to my mind, Chair, there seems to be a lot of conflicting views on what we heard today. And so a consolidated report that we could interrogate as a committee, I think would help us have a firmer basis on which to go forward, and rather than base it on a he said, she said sort of situation. Chair, I do want to caution against attacking other members for sharing their input. I think we are all allowed to share our inputs within this committee, regardless of our age or regardless of our gender. Thank you, Chair.
Thank you very much, member Mari. Johan.
Thank you, Chair. Chair, through you, I'm going to ask members not to crucify me, please. Because there's now been proposals and various members have now spoken on it. So I must now capture this in the minutes before the committee makes a decision. So I just wanted to get it clear what I understand. So I understand actually that member Bosman made a proposal or moved a motion, which I will read the way I've captured it now. And this is where members may or may not agree with me, but I actually get the idea that member Nkondlo and member Mare agrees with that first motion on the legal. I think there's a dispute of whether we should use the word report or opinion here. And then there was also a member America who mentioned that he disagrees, but I'm not sure what member America is saying exactly. Because, and I'll tell you now, sir, why? Because member, okay, I'm going to my minutes, so I won't see any hands now. Just give me a minute so I can get what I've read here. Because member America spoke about a legal opinion, so members can just clarify. But what I have here is, and this is what came from member Bosman, I think, and I just want the committee to correct the wording here. Mr. Marsdorp to revert to the committee in writing regarding the constitutionality of the bill. And I've added here what Mr. Marsdorp himself mentioned earlier, I think, and whether federalism is promoted in the national constitution, 1996, full stop. That's the first one, and I understood most members to agree that what Mr. Marsdorp have said in this meeting must just return back to the committee in writing. I understood Mr. Bosman to say that and Mr. Marais, but not that I want to speak on behalf of members. I'm just saying what I understood. So I'm speaking too much. Let me just read that again and members can amend it if they have to. Mr. Marsdorp to revert to the committee in writing regarding the constitutionality of the bill and whether federalism is promoted in the National Constitution 1996.
That's the first one. Is everybody happy with those wordings, colleagues?
Sir, no, I never said they must ask whether federal is promoted. I said we have all the ingredients of federalism. We have a president, we have 9 provinces. Each province has its own parliament, its own legislatures. So that's federalism. It's only the amount of powers devolved that differ between states and a central government. That's the only thing missing. But we are, in fact, a unitary state with devolved federal powers. But my main argument was we must accept Mr. Marsdorp's report. The only thing is he must put it in writing. Finish.
Member Nkondlo.
Thank you, Chair. I think where we may find ourselves stuck in this meeting until late is really on semantics. Because here, if we accept based on the inputs, because Advocate Marsdorp responded first and foremost to questions that were raised by us, he further went into the proposed bill and made opinions on sections. So that's exactly what we said. We want all of that information, which he had to provide to us here. So that is why, Chair, once you want to start saying he must make an opinion on the constitutionality versus whether federalism, in terms of trying to scope what he must speak about, all I, from where I'm standing, I would want to support is exactly the issues that were raised by Advocate Marsdorp in this meeting related to the questions which include constitutionality and an opinion which he said at this point is unable to get into about the federalism of the South African governance mechanism is something that he can come back and provide, including all other matters that he had already raised here verbally. So if we could just couch it there in terms of the report, so that we then come back based on the inputs that he has already made here in this meeting. I'm not sure why are we getting into, different, trying to break this thing into pieces, because it's going to keep us in this meeting unnecessarily.
Thank you, Member Nkondlo. I think Johan is listening. Member America, then Member Bosman.
Thank you, Chairperson. Chairperson, I just want to erase any ambiguity with regard to what I stated. What I try to solicit from this particular meeting is that a legal opinion should be provided. And for me, it is not a question of where it needs to be sourced from. And I think Advocate Marsdorp is very competent and able to do so. And perhaps then my view is that not a report, but a legal opinion from Advocate Marsdorp in the context of whether the provincial parliament, this particular bill, fulfills the mandate of the provincial parliament. Thank you, Chair.
Before you speak, John, I'll give to Member Bosman. This is the last one.
Thank you, Chairperson. Chair, I also just want to add that I did not ask for a opinion on federalism in South Africa. I'm quite clear on that, so I don't need that. But I do think that as a committee, we need to ask that a legal opinion is tabled in this committee on the constitutionality of the bill. And also maybe perhaps as Advocate Marsdorp took us through a clause by clause, sort of focus on the legal aspects that he highlighted. So my proposal would be that the committee resolves to get a legal opinion from the legal services at the Western Cape Provincial Parliament, highlighting those items. Thank you.
Thank you, Member Bosman. Before I get into trouble again, I see Member Maran is number 2. Member Maran?
Yeah, thanks, Chair. I just wanted to check because I've heard 2 different views now. Although the Honourable America and Bosman are on the same page saying that they want a legal opinion. If I heard correctly, the Honourable America was saying if the Advocate Maasdorp can give us a legal opinion. But I've heard now the Honourable Bosman speaking about getting a legal opinion from the legal services and not specifically Advocate Maasdorp. And if that's the case, Chair, then we question the ability of the Honourable Maasdorp. If we are saying that we need now a legal opinion from someone different than Advocate Maasdorp.
Thank you,
Chairperson, before we continue, if I can just check with Honourable Maasdorp, he still works for the legal services in the Western Cape Provincial Parliament, doesn't he?
Are you afraid to say that we need a legal opinion from the Advocate Maasdorp?
No, Advocate Maasdorp is part of legal services, Mr. Maran.
Colleagues, I see Member Advocate Maasdorp's hand is up, and there's no members. Advocate, I'll give it to you.
Is the DA allowed not to put up their hands like Bosman and just speak, and the rest must put up their hand? Or do we have 2 different rules for the DA and the other parties?
No, we only got 1 set of rules for all members. Thank you very much. Advocate Maasdorp. I recognize you, sir.
Thanks so much, Chairperson. Chairperson, maybe just two observations. The first is just some appreciation for the comment from Member Murray that she made earlier in relation to me. But I can certainly assure you, and I can certainly console you, Member Murray, that I do not feel undermined. In any case, I cannot be undermined by a fellow human being. That can never happen. Not by a fellow human being. Secondly, Chairperson, I do know earlier that I said that in preparing for this meeting, of course, one can't anticipate the questions, and therefore you can't fully and comprehensively prepare to advise the committee, because, like I said, it's a dynamic meeting and many questions come up. And if it is that there's an issue that pops up, which I did not foresee or which I did not thoroughly respond to, then I would ordinarily seek the committee's indulgence to and undertake to revert to properly advise and properly assist this committee. I do know that in the organic development of the meeting earlier, that Member Murray raised the issue of whether federalism is provided for in the Constitution, and I think that may have been in response or excited by something that I said. Now, and that has popped up again now, the issue of the role or the presence, if you like, of a provision in the Constitution regarding federalism. I note the observation that Member Murray made as far as our constitutional architecture is concerned. But in as much as I undertook earlier to revert as far as the issue of federalism is concerned, I want to maybe request direction in respect of the following statement. Is it that the issue of federalism, is that issue germane to this bill? This bill does not speak about federalism. This bill does not speak to federalism as a desired state or federalism as the premise on which the bill is predicated. I would not want to necessarily get into a situation where I provide the committee with an opinion on federalism as an academic exercise and not as any value to further the discussion on the substantive issues of the bill. I'm of the view, on reflection, that any input, written or otherwise, on federalism and its relevance in our constitutional architecture is academic. It is not germane to this conversation, and it won't take the conversation on the constitutionality of the bill on its substantive content. It won't take it any further. However, I'm an official of WCPP at the behest of this committee because I've been assigned to this committee. If this committee feels that the issue of federalism needs to be interrogated by Master, he must give us a written view on federalism in the Constitution, because without that view, we cannot take any step further with this bill, and we cannot go to public participation without that view, then I will do it. I have reflected. I'm of the view that the issue of federalism is not germane to the content of this bill, would actually be irrelevant to consider the constitutionality or otherwise of this bill. But as an academic exercise, I can certainly provide that. I need guidance from the committee. Thank you, Chairperson.
John?
Chairperson, if I may I share my draft minutes with the committee so that the wording of the proposals can then be gotten correct here?
Yes, please do that, because seemingly we are just playing with words now, and which means the same thing said differently by some say Marie, some say Murray. So,
Chair, I'm very bad with technology, but I think, can you see it there, Chair?
Make it a little bit bigger for the members.
Okay, let me try my best here, and let me read through it before members. And I won't be able to see members. Is that big enough, Chair?
Yeah, it's okay.
Okay, so Chair, now firstly, I will not be able to see members' hands because I've got this document open.
No,
so
it's fine. I'll check. I'll assist you there.
You must just stop me. So what I've got now and what I've taken out of the conversation, members can tell me if this is correct or not. So the first point I've changed a bit. I said Mr. Maasdorp to revert to the committee in writing regarding the issues that he raised in the meeting and the constitutionality of the bill. So let's just maybe stop at that one, Chairperson. And
is everybody happy with that first line, colleagues? Going once?
I'm happy.
Member Bosman?
Chairperson, I think we were very clear that we want Member Maasdorp to revert to the committee in writing with a legal opinion on the constitutionality of the bill. So that word, because my understanding is that a legal opinion is different from just a report. And then I don't think we need point 3.2, as Advocate Maasdorp explained. That is an academic exercise, and I think we can all do that kind of research on our own.
Okay.
Colleagues?
Sorry, Chair.
Yes, John?
No. So should I delete 3.2 then?
No, we'll just want to deal with the first one, and then if the members feel that we don't need 3.2 and 3.3, then it will be fine. But the only addition to the first one is the issue of the word legal opinion. Is everybody happy with that one?
Sir, can I speak?
Yes, Member Murray.
Legal shouldn't be there. With an opinion regarding any legal or constitutionality of the bill. Then you don't have to get a legal opinion. That means you are going to now get people, and I know how the politics work, that will give them a nice report on the legality. We want a report that's not politically motivated. Otherwise, we're going to land up in the Constitutional Court in any case. So unless we get this right, there's going to be constitutional challenges. So let us say that we are asking the committee, ask Mr. Maasdorp to revert back to us with an opinion regarding the constitutionality of the issues raised. Chairperson, when you have 5 lawyers, you get 5 different opinions. 10 lawyers, 10 different opinions. That's why there's a court to decide.
Okay, noted, Member Murray. Member Murray, I see your hand.
Thank you, Chair. Chair, I think today has been an exercise in semantics. And my concern
For me as well.
yeah, and name pronunciations. Chair, I would like to propose, given that we can debate every single line within the proposed minutes before us, that we vote on whether to adopt it as a whole. But Chair, also just going back to the question of whether to speak to the issue of federalism, for me, as a Member of Parliament, who will be dealing with this bill, and likely also the bill proposed by Member Murray's party, I think the question of federalism is going to come up quite a lot, especially as we go into public participation exercises. And that's why I would greatly appreciate that feedback from the legal advisor. Thank you, Chair.
John?
Yes, sir.
I think before you go, John, I will just like to address Advocate Mastop. Advocate, I would just want you to assist me in this regard. That do you find anything problematic with the addition of a legal opinion in terms of Resolution 3.1?
No, Chairperson, that is fairly in order.
Okay, thank you very much. So is everybody happy that with 3.1?
Yes, Chairperson.
Yes.
Thank you very much. And colleagues, in terms of 3.2, should we keep it or should we take it off?
Chairperson, I think we should take it off.
I support, take it off.
Is there a counter proposal?
Not relevant.
No, we are in agreement, Chair.
Thank you very much. Wow, welcome back, Member Mosek.
What do you mean? I've been here.
Okay,
Be
Chair.
quiet.
So I'm taking it off, Chair.
Okay, and then
I'm pressing the button.
3.3, do we take it off?
Yes, take it off for now.
You must
No,
raise your hand.
Chairperson, no.
No, Chairperson.
No, Chair, that it stands.
Yeah, because it says the committee to decide on a public participation after having received the written document referred to in 3.1.
Yes, I agree to that.
Yeah,
No,
Yeah, no,
Chairperson, I
Chair,
think
it's fine.
we
It's
need to
fine.
amend that.
I'm fine with it.
Wow.
After having
Chairperson?
received the written document.
Chip.
I see.
Bossman.
Yeah,
I
I'm
see.
fine with that. I always raise hand, you don't recognize me, but it's fine.
Member Class, I didn't see that you raised your hand. Is there something that you want to say? Welcome to the meeting.
No, I said it's fine. No matter you didn't recognize me, I'm with you in this point. But I wanted you to recognize me when my hand is just only.
You are recognized, member, and you know I love you very much.
Chairperson, I'm also here in the meeting. Member Brankes, I'm here in the meeting.
Oh, welcome, Member Branges. Okay, thank you. Okay, colleagues, so those are the 2 resolutions. Advocate Masdop, I see your hand.
Chairperson, my hand is up as well. May I speak?
Sorry, okay.
In terms of the resolution 3.1, it is fairly open-ended. There is not a time frame attached to it by when do we want that opinion, because in terms of when this committee will meet again will then influence 3.2. If we can clarify that and find common consensus on those timeframes, then I would go along with 3.2. Other than that, I'm of the view that if the opinion is going to take 21 days, then we should, in a pro forma way, put down a a schedule for the implementation of 3.2. Thank you.
Okay. Advocate Masdop, how long would it take for us to get for resolution 3.1 to be executed with everything that you are able to deal with?
Chairperson, it's very difficult for me to give a time, but I will certainly appreciate as much time as the committee will give me. Now, how long is a piece of string? Certainly anything from 15 to 20 days, Chairperson, that would assist. And I'll tell Chairperson why my thinking is that in legal services, we certainly try to have a very diligent turnaround time in respect of bills and particularly assisting committees. And similarly, in this case, that is my mindset. But I think in terms of not in terms of, but mindful of the gravity of this bill and its future implications, the kind of research that I am anticipating to do will be certainly my own research, but also because I'm a human being and very mindful of my own limitations, I will try and have time to consult with constitutional law experts at tertiary institutions. I will gather their opinion and hope to incorporate that with acknowledgement in my own views. So I will do my own extensive research for the benefit of the committee. I would hate to think that I will provide an opinion in order to squeeze myself into a timeline because there's the prospect of public participation waiting for the committee. I will stand by the letter of my opinion once I am convinced that it has been thoroughly researched. I will not give a wishy-washy one, only to answer in the highest court down the line that I said certain things within a timeline that was not conducive for proper research and advice to a committee. So in as much as legal services try to give advice at a quick turnaround, I will not commit to that. I will give advice at the quickest possible turnaround, having done extensive research for the very benefit of this committee. That being said, I think only once that has been done can the committee proceed with deliberations on public participation. Because if it is that I would provide an opinion along the line that I gave earlier, and the committee deliberates that it is constitutionally risky to proceed with this bill, then it would be inconsequential, a useful, fruitless waste of time and energy and funds to engage the public on a bill that may be dead in the water down the line, So I will need as much time as this committee can possibly give me so that it can be assured of quality advice. Thank you, Chair.
Okay, thank you very much. But Advocate Mazo, before you close, are you comfortable that we keep 3.2 there, or should we deal with 3.2 when we have received your opinion?
Chairperson, it would make sense for 3.2 maybe read that the committee after receiving the opinion and advice in 3.1 decided public participation. Well, I think it does say that.
It does say that, yes.
It does say that. So if the one is a consequence to the other, then it makes sense.
Yeah, okay. I think the only issue that is outstanding now is the issue of the time. And maybe Member Member Bosman will assist us in that regard. Member Bosman?
Chairperson, I am not sure whether 10 days would be sufficient, but that would be my proposal. But I also want to urge the committee to decouple the legal opinion from the public participation. I think the public participation is a process that can continue whilst the legal opinion is being formulated. I think any opportunity here from the people of the Western Cape is not a fruitless exercise. So my proposal would be that 3.2 is decoupled from 3.1, and that we amend 3.2 to say that the chairperson and the procedural officer draft a public participation schedule, including a draft advert for the committee to consider at its next meeting, which should be in 14 days' time. Thank you, Chair.
I second that, Chair.
Chairperson, can't we put in 3.2 and consider the written document? Are you just going to accept it and have a public participation? Or should it say the committee to decide on public participation after having received and considered the written document?
John, I need your guidance here and Advocate Masdorp in terms of that.
Chair?
Chairperson,
Just before you, John, and Member America?
There's a proposal by Honourable Bosman, and I support that proposal. And maybe we should first entertain that proposal before we consider 3.2 as it is. Thank you.
Or the issue of the date.
Yes, sir.
Okay. So is there a seconder for the 10 days?
And the decoupling. Thank you.
And the decoupling of 3.2.
Chairperson, is this 10 working days?
Yes.
Yes.
I second that, Chair.
Okay. Is there anyone with a problem?
No, Chair.
I see Advocate Masdorp.
Chairperson, I need your assistance. After Member Bosman spoke, I became confused. You see, Chairperson, we are sitting with a bill and there may be questions pertaining to its constitutional integrity. We therefore, as is very prudent, seek advice on the way forward in terms of us as a committee making up our mind on whether we will accept that this bill is constitutional or not. That is why I have been given 10 working days to assist the committee with that advice. Now, I'm not a member. I don't know how the mindsets are inclined, but it baffles me when there's a proposal that whether or not the bill is constitutional or not, in your opinion, we want to do public participation. Proposals like that baffle me because it is devoid of logic. And Chairperson, I have not intimated that a chance to speak to the public is inconsequential. But as a prudent official, it would not make sense to have a community in the province consume, digest a bill, potentially unconstitutional, and for us to traverse the province on public funds to see the community, to hear their sentiments, only for later, 10 days later, to find out that the bill is unconstitutional. I think a proposal like that is devoid of logic. I would recommend, that's just me, I would recommend that the committee put its deliberations on public participation in abeyance, that if I come up with a report with an opinion, having done my research, that the bill is potentially unconstitutional, then it is at the committee's doorstep to motivate for public funds to go on a public drive to propagate a bill that is potentially unconstitutional. I am saying, Chairperson, that 10 working days from now is maybe a stretch. I would have liked more, but if that's what the committee wants, that's what I will do as an official. But to already decide on public participation, unbeknownst to the nature of the opinion, is baffling to me.
Chairperson, I agree with that input of Advocate Masdorp.
Chair, my hand is up long time ago.
Mine too.
Colleagues, please don't speak before I recognize you. I see Member Maran and then is Member Mare.
Thanks, Chair, and I want to concur with Advocate Masdorp because it seems that we are now predicting the outcome of the legal opinion, and therefore we are saying at all costs that the public participation process must continue. And if that's our mindset, what's the reason then of asking for a legal opinion if we're not going to consider that particular legal opinion, whether we should have a public participation process or not? My understanding is, Chair, is that the legal opinion that we're asking from the advocate is assist us whether the public participation process will continue or not. Because it might be that the legal opinion will find that the bill that's currently in front of us is unconstitutional, Chair. I fully agree with him, Chair, and he called it devoid in logic. Strong words. So my Chair is that we should wait for the legal opinion, discuss it, what the outcomes is of that, and based on that outcome, Chair, of the legal opinion, will be determined whether there will be public participation process or not. Thanks.
Member Murray, and
Yes,
then
thank you.
Member Bosman.
Thank you, Chairperson. I think I want to support Mr. Honourable Member Moran. We mustn't rush this thing. I don't know what is the haste. Can anybody tell me why are we rushing this? If I didn't say we were going to consider it in 3.2, this committee might have just said, okay, we got the report even if nobody got a copy, and now we have a public participation process without having considered at first the report. So I think there's a tendency to want to rush this through at high speed, and I want to record my shock and dissatisfaction with the way the direction this is going. It's no use having a majority and then wanting to force your opinion. Let us sit down, get the report, deliberate on it like we did now, and then after we have reached consensus, to say sufficient consensus, then we go to the public and we present the bill to the public united. Otherwise, we can have public participation and we will be arguing in front of the public about the acceptance of this bill.
Thank you, Member Murray, Member Bosman, Member Mari, and then I will make a decision.
Chair, would just like us to put 3.1 to get some finality on whether we made a decision on whether we are happy with 3.1 as it is. If we could just vote on that, and then we can move to 3.2.
Okay. Is everybody, before we go to other speakers, is everybody with the wording in terms of 3.1?
I'm fine with it, Chair. 10 working days.
Yeah, is happy. Is there another one that is there another against?
I'm also happy. I'm also happy, Chair. Member
Thank you very
Francis, I'm
much.
also with that.
Thank you, colleagues. We are done with 3.1. I see Member Marie.
Chair, sorry, it was just to express support for having the report done prior. Yeah, thank you.
Okay. Member Class.
No, I'm happy with 3.1. Only just I said we have to continue with this project. This project. Otherwise, we are going to speak words that are nice and that. So I will rather say that let us continue with this one, and then we wait when they come after that 10 days to discuss other matters. Thank you.
Thank you, Member Class. Member Bosman. We done with 3.1. What are you dealing with 3.2?
Yes, I am.
Thank you.
Chairperson, what I'm asking for in 3.2 is not that we agree on the dates. I'm asking that we give an opportunity for the chairperson and the procedural officer to plan those dates. So we already know that we're getting a report in 10 working days. So nothing stops you as the chair and the procedural officer from initiating the plans for public participation. Whether that takes part from the 20th of August, or whether it takes place from the 17th of August, it requires quite a lot of work. And it requires the drafting of adverts. It requires negotiating with the programming authority for dates. So what I'm proposing is that the committee empowers the chairperson and the procedural officer to start the planning on the public participation process. Thank you, Chair.
Is everybody happy with that one?
No, Chair. I'm not
Yes,
happy.
Chair. Yes,
Happy
Chair.
No, Chair, I'm not happy. I think we are too hasty
You're
and we are
not part of the
too.
committee.
Member
Look,
Branges,
Chair.
you must raise your hand, then I will acknowledge you. Member Maran.
Thank you, Chair.
Look, Chair, the planning phase, Chair, is also going to require funds. Chair, it's going to require funds. It's going to require work, focus, and everything is going to require funds. And as been said by the Honourable Murray, I'm not sure what is the haste. I'm not sure. We're going to put in all this planning, and if the outcome of the legal opinion is that this particular bill might be unconstitutional, then the planning that's been done will be null and void. Chair, I really, Chair, wants us to consider to not having 3.2, Chair, but to wait for the outcome. And if the outcome is positive, we can then start working and planning for the public participation process.
I see Member Bosman.
Chair, I propose that we put to a vote my resolution on 3.2, that the committee empowers you as the chairperson and the procedural officer to start the planning process for public participation.
That's the proposal. Is there a seconder for that proposal, that we adopt a resolution 3.1 as it is and 3.2 as it is, as per Member Bosman? Is there a seconder for that?
Seconded, Chair.
Seconded, Chair, by
Member
empowerment to you,
Maseko?
procedural officer.
Is there anyone against that?
Yes, Chair. I want to propose that we leave out 3.2.
Chair, if I can just add while my hand was raised. I think that it is fair for us to plan, but that planning be subject to the feedback that we receive from legal, and perhaps we can add a line to that effect.
Member Bosman, as you propose it, are you happy with that amendment?
No, Chairperson, I don't think it's necessary. We will make a decision when you and the procedural officer presents us with the information like we always do.
Okay, cool. Colleagues, let's not complicate things. There's those two proposals, and it was seconded, and there's a counter proposal from Member Maran. Can we just get an indication for those that are in favor of the proposal?
Chair, my hand is up. Chair, my hand is up. Member Branques, I want to second the counter proposal of Member Maran to take out 3.2.
Are you part of the committee? Can you just assist me there, John?
Sorry, Chair, I wasn't focusing. Who's speaking now?
Member Branques.
Is Member Branques speaking?
I don't know, Member Branques, are you a member of this committee?
Chair, I'm not a member of this committee, but I do have a right to speak after I've raised my hand, and I did raise my hand.
Member Bosman?
Chairperson, I don't want to take away from Member Branques' right to speak, but Member Branques, not being a member of the committee, but can't second a motion. So technically, my motion is the only one that's valid, Chair, because it's the only one that has been proposed and seconded.
That's why I was asking whether he's a member of the committee, and seemingly there was no seconder for the proposal of Member Maran. So, John, we have dealt with that one. The majority agrees that we get the resolution as it is.
Okay, so Chairperson, let me just get this correct. So you can see my screen, so I'm deleting this part. Is the committee saying that? I'm deleting this part that I've highlighted.
Member Bosman?
Yes.
Yes,
Okay.
that is correct.
I'm deleting that. And then, so it reads now, resolution that the committee empowers the chairperson and the procedural officer to start working on a public participation strategy. Is that correct?
Who's that? Colleagues, can you just mute yourself?
Just mute member class.
Member Class, can you mute yourself? Member Bosman, is that your proposal? Are you happy with that?
Yes, Chairperson.
Okay.
Chairperson, just the word strategy was not used, it's the word plan. So the public participation plan.
As I'm asking you that.
Oh, we don't change it, Chairperson. That's the DA. They want the strategy, not the plan.
Member
So let us-
Moray, Member Moray, please. Please.
Exactly, Honorable Moray, strategy.
Member Moray, John, so we've got the resolution as it is.
Yes, sir.
I think we can move off this topic now. We got it.
Okay, so these two have now been resolved.
It's been resolved, yes.
Yes, those are the resolutions.
Yes, that is those. Is there any other resolution that members want to include?
No, Chair.
No, we are done. Happy. Gone. Finish and clear. Is there any matters of the committee that we need to deal with before I conclude?
No, Chair.
I'm speaking to Joanne.
Chairperson, you know what? I made a mistake. I never included the minutes.
Okay,
Yeah,
that's
but
it.
we can deal with that next time because it was the election of a chairperson. We don't have to deal with it now. It's fine, Chairperson. I don't think there are any other matters.
Oh, colleagues, from my side as a chairperson and to everybody that was here, it was a very, very robust discussion. And to those that felt offended by me not recognizing them, it was not done on purpose. And thank you very much for your participation. I will await Mr. Masdorp with a legal opinion. As soon as we get it, then we'll engage and then we'll take the process forward. From my side, thank you very much for your participation and for your indulgence. And I wish you a blessed evening. Meeting adjourned. Thank you very much.
Thank you,
Thank
Chair.
you, Thank you very much. Thank you, members.
Thanks, Chair and everyone.